Namaste, Sakshi, Manasakshi. I am Priya Koteti. Welcome to Sakshi TV special immigration show with attorney Ms. Prashanthi Reddy from Law Offices of Prashanthi Reddy PLLC. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided on this show is not a legal advice and for general information purposes only. Sakshi TV or its agents will not be responsible for use of this information. If you need specific legal advice, please contact the attorney directly. So without any further delay, let's start our show. So hello Prashanthi, how are you and welcome to the show.
Hello Priya, I'm good, thanks. How are you?
I'm good, thank you. So Prashanthi, like as usual, can you please update on your information on law officers, practice areas, and your experience?
Yeah, sure. We are located in Midtown Manhattan. I have 20 plus years of experience in business and family immigration law. If you need to reach us, we are available on www.reddyesq.com.
Yeah. So viewers, today we'll be discussing on L1 and other alternatives to H1B visa. So before we get into the topic, you can call us on the numbers on the screen for question related to immigration and also ask some tips. So let's get into the topic. What is the nature of this L1 visa and how long is it valid?
So yes, today's topic, as you were saying, is related to L1 and other alternatives to the H1B. As we all know, the H1B cap cases, the cap is soon going to get over. The cases have to be filed by the end of this month, all H1 cap cases. So by the end of the month, that will be done. And maybe there will be another lottery. We don't know. Most probably there will be, and there might be a few more cases filed after that. But in general, the cases that were to be selected under the cap, the opportunity to file your H1 under the cap to register is over because that was done in March. So now if any employers have new employees that they need to hire, and if those employees have never been on a H1 before, then they can only do it next March with the start date of next October. So that's a long time. So it's important to discuss what the alternatives are for the H1B and if there's any other work visas that can be used in lieu of the H1 since there's no H1 availability right now. So one of that visa is the L1 visa. And with reference to the L1, as you were asking, Priya, it's valid for, it actually depends on whether it's the L1A or L1B. But the L1B visa, which is the specialty occupation one, is valid for 5 years. And the L1A is good for 7 years. You can file for 3 years extensions. And with reference to who qualifies or what's the nature of the L1 is basically a intra-company transferee position, meaning the person is being transferred from one company to another company, meaning from the company abroad to the branch office or the affiliate or the subsidiary in the US in order to help run the operations in the US or maybe start up operations in the US depending on what the situation is. So not anyone can be transferred. It has to be an executive position, basically a multinational executive position. So key employees can only be transferred. And there has to be a relationship, as I was saying earlier, between the US company and the foreign company. So that relationship should be that of a branch, a parent subsidiary kind of relationship, or an affiliate company relationship. And then you can transfer your top level manager or specialized employee if it's L1B to the US. So the entity in the US, as I said, could be a branch office or it could be a parent subsidiary. To establish parent-subsidiary relationship, you have to show that one entity owns 50% of the other entity and has control over the other entity. So, for example, it could be that the India or the foreign company has control over the US company because they own 100% of the shares or more than 50% of the shares. So that's what is important. Now, they could also be affiliates, which means siblings. That is, both the companies are owned by one, company above them. So they're a group of companies, and they're both owned by, like, say, a company A, by the parent. So that makes them affiliates. And as I said, the employee has to be working in an executive, in a managerial, or specialized knowledge capacity for at least. So they should show that they were working in that capacity for the past 1 year in that foreign entity. And when they were working for the past 1 year, out of the last 3 years, 1 year is the requirement. And you have to show that that relationship existed at that time, whenever they were working. So there, as you can see, there's quite a few requirements.
Okay.
And it's valid for 7 years. It can be converted into a green card. For the L1A, you can file for an I-140 directly. There's no labor cert after 1 year. For L1B, you have to go through the labor cert process the same way you would go for the PERM, the I-140 for 85. You have to go through the entire process. So for new entities, if the US company is new, or for that matter, the India company is less than a year old, then you only get it for a year first to start off with.
Okay.
And then you can apply an extension for further 2 years. But if the US company is more than a year old, then you can get the L1 for directly 3 years at a time. So these are, I think, some of the nuances of an L1 petition.
Okay. So even we can do this acquisitions and mergers, like Indian company can acquire some company, we can do this acquisition mergers and send someone on L1 visa, right?
Yeah, as long as that 1 year period is over since the date of the acquisition, and that
Okay.
person worked in that 1 year when that relationship existed.
Okay. So what is the minimum investment required for this?
So there's no minimum or maximum investment. It's not an EB5 or an E2 visa where there's a certain specific amount of investment required. Basically, the requirement is whatever revenues are required to support the running of the organization. So different organizations could require different amounts of money, right? For example, if you're in the precious stones, precious gems industry, if you're a jewelry industry, you'll need millions of dollars just as preliminary investment because you have to buy those. If you're a dealer, you have to acquire those, gems in order to sell them. But for example, if you're an IT company, the only investment is your employees. So you may not need any great investment. It might just be that you need, to open an office space, to have enough money to maybe pay the first 3 months' salaries. That's what is looked at, the nature of the business and how much that business would need to function, at least for the next 3 months.
Okay.
If you are into some kind of a retail industry, then maybe you have to buy those products. Or maybe if you're into manufacturing, maybe you have to set up the factory, so you need money. So it really depends on the nature of the business, really.
Okay. So what kind of company can open a branch of subsidiary in USA under this L1 visa?
It can be any business, any
Okay.
type of corporate organization. So you can, first of all, it can be any type of legal organization. It could be an LLC, it could be a C corporation, S corporation, whatever it is. It can be anything. As long as it is legally, it's registered legally. And you can have any kind of business also. But usually the business is same as the parent company business. But any lawful business, it's possible to open on the basis of any lawful business.
Okay. So, like I was in an impression that L1 visa is only mostly for the IT companies, but it can be like across any field of business, any line of business.
Right, it could be anything, garment industry, garment industry is very common for them to, have that. At least in the past, it used to be when the garment industry was big. When in India the garment industry was, doing well, a lot of garment companies would open businesses and file L1s. So it could really be any kind of manufacturing or garment or IT or healthcare, whatever it can be anything really.
So is there a time frame for establishing a branch or subsidiary under this, like to obtain L1 visa?
Well, it doesn't take long to establish a company. Maybe um, you can incorporate in about a week or 2 weeks. You have to choose a name and go to the you can use LegalZoom or any other person who incorporates for you, and choose 3 different names, and the state will do a name check to make sure that there are no other names with that company located. And if they find that there's a name, then they'll use your second choice and then third choice accordingly, because they want to make sure that there's no duplication of names. So once you go through the name check, you can incorporate pretty quickly in New York, about a week or so. And then, of course, there's other preliminary work to be done before you can file the L1. You have to open a bank account, maybe transfer some funds, starting capital like we talked about earlier. And get an office space, get a lease of an office space, a commercial space out of which you plan to operate. So all this shouldn't take more than a month.
Okay. So, like, what is this? What is the nature of business that is legally permissible under this L1 visa?
As I said earlier, any business, as long
Okay.
as it's not an unlawful business. You can't deal with drugs unless
Yeah.
unless it's legal in some states. It is so. Unless so any illegal business you cannot do. It has to be something that's lawful. And usually the type of business of the parent and the foreign entity is usually the same.
Mm-hmm. Okay. So this does this L1 visa enable the principal applicant to sponsor his family members under this visa?
Yeah, so the family members, the spouse and children can come on an L2.
Mm-hmm.
And the advantage of the L2 when compared to other dependent visas is that they automatically get permission to work.
Okay.
So the L2 spouses are allowed to work, which is a good thing. H4 spouses also are allowed to work now, but only some H4 spouses, right? People
Yeah.
whose the primary applicant has an I-140 approval. Those people are allowed to work. For the L2, they've always had permission to work. So that's a big advantage. And they don't have to file anything in the US. They can just come apply for a visa directly, an L2 visa at the consulate, and then come in, and then they'll be given a I-94. And the duration of the status is the same as the principal applicant. As long as the principal applicant is on L1, their dependents will be on L2. They can go to school, they can work, whatever they need to do.
Okay. So generally for H4, like H1 dependents H4, they have to wait until they get a EAD card, like I-140 approved. Then after they get a EAD card, they can start working. So in this case of L2, so once they have this L2 visa stamped, so they can directly start working, or they also need to apply for some EAD card or something like that?
Yeah, actually, as per the law, they are automatically eligible for work, so they don't need to apply. But USCIS has been interpreting it in such a way that they also need to apply and then go through biometrics. But of course, they have stopped biometrics, right? Asking for biometrics for certain EAD holders or EAD applicants. So yeah, they do have to go through it, but I think that's incorrect. They shouldn't be asked to go through it, but yeah, they have to apply for an EAD as well.
Okay. So how long does the company or firm has to be in the origin country? Like if it's in India, how long has it to be in India to obtain this L1 visa, like to raise this L1 visa for its employees?
So it's not you can't do for okay. So the L1 East visa is applied by the US company, not by the India company.
Okay.
And the India company or whatever, the foreign company has to be in business for at least a year, right? Because as I said previously that beneficiary, that employee should have been working in that company for at least 1 year in a managerial, executive or specialized knowledge position to qualify for the L1, which means that they should have been in business for at least a year. And the relationship as it exists, the qualifying relationship should exist for at least a year.
Okay.
So total, the answer to your question is 1 year.
Okay, got it. So like we spoke about in like few episodes back, like on the H1 documentation, required documents. So do we have any required documentation for L1 also?
Yeah, there's a lot of documents required for an L1. So basically, you have to first show that the foreign entity is a viable company, which means that they have, which means that it's likely that they will continue to be in business. They're not going to go out of business. So you have to show that they have healthy, turnovers, a good performance record, good financials. Most important, you have to show that, if you're showing this person worked in an executive or managerial level, you have to show that he supervised other people. So if he's the only employee, you cannot work in a managerial level. Who is he supervising? So you have to show a certain number of employees. Especially if you're doing the managerial level, you have to show that he actually supervised 2 levels of people. Like in an org chart, if you have an org chart, 2 levels of people and both of them have, the job requires at least a bachelor's degree. So that's a requirement. So therefore, there has to be a certain number of employees in the India company, and that has to continue in the US company as well, because you have to show that number of because again, for executive positions or for managerial positions, you have to show that they are going to, even if they haven't started doing that yet, because it's a startup. You have to give a business plan where you show that you're going to hire X number of employees.
Mm-hmm.
And you have to show a future org chart. And you have to show who the employee will be supervising. So from the Indian company point of view, you have to show their tax returns. You have to show that they have office space. You have to show their how much business, the scope of their business. You'll have to show their bank statements, their contracts, org chart, etc., etc. And basically, the US company also, the requirements are pretty much the same. As I said, if it's a startup, then you don't need to show financials. You simply have to show a business plan. You have to show lease, bank statement where you have enough money to at least 3 to 6 months to be able to sustain the business. And then, of course, you have to give a detailed account of what the beneficiary, what the employee did in the foreign company, and to show that he actually worked as an executive or as a manager or whatever qualifying job he had. You have to show that clearly. And often USCIS will send long requests for further evidence to prove that the beneficiary worked for the Indian company in a qualifying position. And they'll scrutinize every job description that you send. So if you say in the job description that he used to pick up phone, answering phone calls, arranging meetings, then they're going to say that's clerical or administrative, that's not executive, so he doesn't qualify.
Mm-hmm.
So you have to make sure that the duties are executive in nature. And the same thing with the US company, you have to prepare a detailed letter showing what is the relationship between the two companies. So in order to show relationship, again, going back to the documents, you have to show the share certificates of who owns the US company. And you have to show that it qualifies as a parent or a subsidiary or as an affiliate, as we discussed previously.
Mm-hmm.
You have to document that. And you have to show ownership of the foreign company as well. And then, as I was saying, the petitioner letter from the US company has to basically detail how the position qualifies. So you have to show this is what he's going to be doing. And this is his executive duties. These are his managerial duties. If he has These are his specialty duties. If he has all three, then good, put that down. Be careful when you're formulating the duties. Again, you don't want to put in clerical duties. Also, it's important that there is someone else to take care of those clerical duties. If he's again the sole employee, they're going to say that someone has to pick up the phone, someone has to answer calls. So it looks like that this executive will end up doing that, and therefore we don't believe that this position qualifies for an L1 specialty occupation. So make sure that you have those employees in there. If they're not presently working, show that they will be hired and show the timeline within which they'll be hired. Again, it's another important thing is to show what kind of business, showing the scope of business, like show your marketing material, your brochures, description of the business. USCIS also asks for a marketing plan, especially if it's a startup. How do we know that your business will be successful? Have you done some market research? Who are your competitors, and what do you have? Is there a space for you? Is there a place for you in this particular niche? So that's basically market research. So you have to get someone to do that research and submit that document to show who your competitors are, how they are doing, so they can get an idea as to whether this is a viable business or not.
Okay.
So I think these are the requirements for an L1.
Okay. So generally for an IT employee who is filing an H1 visa, so the applicant, they'll say that he has to have minimum of bachelor's or master's in computer science or equivalent degree. So what is the minimum qualification or experience that is required for an applicant to file L1 visa?
So for an L1A, there is no such qualification. The qualifications that I mentioned, I already mentioned them, right? They should have worked in a managerial or executive position. And sometimes, very often for small companies, they are the owners themselves of the companies that are coming on the L1. And sometimes they've set up their business, they've been running it from the last 20 years. That itself is sufficient qualification.
Okay.
Sometimes you see that they do have additional qualifications, such as an MBA, or they might have taken some special courses. For example, recently I did, for a garments company, I did an L1, and the owner who was looking to come here had a fashion design degree.
Mm-hmm.
And we said that that's how he qualifies. But it's not necessary to show like a H1 that the person has a bachelor's degree. But it counts. Everything counts to show that, to make the case more approvable. So it's better if they have, rather than going based only on experience, if they have a degree, it's obviously better. Salary also plays the same role. There is no specific prevailing wage for an L1. So the Indian companies get away with, and there's a big controversy, right, about that. They get away with paying less than the prevailing wage for the L1s.
Mm-hmm.
But the higher the salary, the better. If you're an executive, you can't be paid $10,000 a year. It should be something commensurate with what other executives are being paid. So it has to make sense. Everything that you say has to make sense, basically.
Okay.
But there's no minimum or maximum salary or minimum or maximum education, unlike the H1.
Okay.
And that's why a lot of the employees prefer the L1 compared to the H1, because number one, there's no cap.
Mm-hmm.
So they can get L1s anytime. Number two, especially if it's an L1B, you can file for blanket L1.
Mm-hmm.
So you're filing at one time for 15 positions, for example. And then you send one by one each person to the consulate. And at the consulate, they'll make a decision as to whether this person qualifies for the L1B or not. So there's nothing being filed at USCIS. It's just that one-time filing.
Mm-hmm.
Of course, you have to qualify for that, for an L1 blanket petition. You have to be in the business for a certain number of years. You should have filed a certain number of L1B individual petitions. You should have certain number of organizations, like certain branch offices, certain affiliate subsidiaries, etc. So Only multinationals, MLCs can do that. The L1 usually qualify for the L1. So that's why you see TCS and all these other companies, Wipro, etc. They mostly file L1s.
Mm-hmm.
Both L1As because they're able to, because they have enough lead positions to file as an executive. And the advantage of the L1A is the green card. They can
Okay.
file the green card within a year, and it's EB1, so they can get the green card within a year. And the B1 is current right now. So that's the big advantage of L1s over H1s. And for the L1B, they can bring in multiple people, much more in number when compared to the L1A. But the disadvantage of the L1B is it's not EB1, it's then EB2 or EB3,
Okay.
based on whatever the position is. You're filing a labor cert.
Okay. So the documentation is different for L1A and L1B?
Yeah, so for L1A, you're showing that the person is working in an executive level, managerial level, or has some specialized knowledge. Usually it's a combination of the three. For L1B, you're saying that the basis for qualification is that the employee has some specialized knowledge of the processes or products of the company, which is unique. Meaning that other people, if they were not your employee, wouldn't have that knowledge. They would have to be trained.
Mm-hmm.
But the person that you're bringing on the L1B has already been trained on it. It takes a while to train, so it's not possible to just hire a US citizen. And it doesn't have to be unique, but it has to be processes and products that are used in your company, which are fairly relatively lesser known. If everybody knows it, if it's just a question of knowing Java, then a lot of people know Java. You can hire a US citizen, right? So it's
Yes.
something that is, while it doesn't have to be something that's unique to your company, it has to be something that is not that the training is not that easily available outside. But mostly the way these MLCs do it is they say that the employees have worked on a certain project, right, while they were in India, and they're coming to the US to continue to work on that product. So they have a unique knowledge of the product, and they have already worked, and they have knowledge of the clients, they have new knowledge of the processes that the company follows. So it's very easy to justify an L1B for a person who's been working on the same product in the past, 1 year, which is a requirement anyway. So that's how it's usually, the L1B is usually done.
Okay. So viewers, if you have more questions and would like to reach out to Prashanthi, you can email at prashanthi@readysq.com or call 212-354-1010 or visit www.readysq.com. So Prashanthi, coming back to our topic on L1 visas. So do L1 visas also have this RFE concept?
Yes, so very much so. They send pages and pages of that RFE, the request for further evidence. They always send.
Okay.
It's not, in the recent past at least, I haven't seen an L1 approved without an RFE.
Oh.
And they ask all these questions. So usually what they ask in a L1 RFE is if it's not clear as to whether there is a relationship or not, they ask for further documentation on that. If it's not clear that they're working, you might just list several bullet points as job duties, but usually they're not satisfied with that. They send an RFE saying, show that those job duties are executive, or show that the beneficiary or the employee is actually performing those duties. What is the proof that they're performing the duties? So if they're working in an executive position and they're managing the HR, that's one of the, they're managing other employees, other departments, then maybe you will have performance reviews that were performed by that employee over their other employees, their subordinates. So you can submit performance reviews. You can submit offer letters that were signed by them, Maybe there's email correspondence back and forth. If they have suggested some policies, then maybe that policy will have an author. They might be the author of that policy. There could be minutes of the meetings. In corporations, usually they have minutes of the meeting. And if some big policy decisions are being made, they usually make it at those meetings. So the minutes of the meetings can show that, so and so made these decisions and this is being implemented. It can be letters being sent out to employees or emails from this person talking about those policies or talking about training, or there's so many documents that can be provided to show that the person is executive. If he is meeting with the clients, or if he's doing that kind of marketing, heads the marketing department, then most probably contracts, POs might be signed by him. Even that can be shown as proof. They may be a signature at the bank if he has an executive position, so that can be shown also as proof. So there are many documents that can be shown, and that's what we usually submit when they ask for an RFE. So in an RFE, they usually ask us to prove that the person is working in an executive, managerial, or specialty occupation position.
Okay.
And if there's any discrepancy sometimes in the documents, then they might point that out and say, why does it say that he's working as a manager in this document, and in this document it says he's working as a CEO? What is his position? Sometimes there's discrepancies which they'll catch on to and then say that based on these discrepancies, it doesn't seem like he's working as a manager like you say. So then you have to give explanation for it. It's quite time consuming, and you have to be very thorough with the documentation that you're sending.
Okay. So we have a caller, Pramod from Dallas. Hi, Pramod. Hello. Pramod?
Hello?
Yes, Pramod. Yeah.
I have a question regarding L1 visa.
Yes, go ahead.
So actually, Prashanthi ma'am, so my wife actually, she came to on-site on L1, L1B, and she got a stamping for 5 years, but we used only like 2 years. After that, she moved to H4 EAD. So can she use the other years if the company is willing to do the L1B later?
So the problem there is that in order to be on an L1, you have to show that 1 year within the last 3 years you worked for the foreign company, right, for the offshore company. So if she's wanting to get back on an L1, she needs to go back, unless it's less than 3 years since she worked for the foreign company. Maybe it might be more than 3 years now because she then changed to a H4, etc. So if it is less than 3 years, then she can, you can file for a change of status to an L1 and make use of the remaining period on the L1. But if it's more than 3 years since she worked for the parent company, then she has to go back, work for the parent company for a year, and then she can come back on an L1.
So she can't change the employer, like if the different employer wants to do the L1B, they can't do it?
Then you can just go back to the parent company of that L1 employer, whoever wants to hire her, work for 1 year, then you can be hired by any company on an L1. The criteria is 1 out of the last 3 years you should have worked for the parent company.
Okay.
Parent company is usually, the foreign company rather, whatever it is, whether it's the parent or the subsidiary.
Okay.
And they should have worked in an executive position or that specialized knowledge position for an L1B.
It's actually executive position.
What position?
It's like executive position, like a team lead.
Oh, okay. So then maybe she'll qualify for L1A, not L1B. Maybe you want to do L1A then, because there's a big advantage of L1A over L1B because L1A is EB1, right? So even if they have Even if they have like a branch in Canada or something, if you want to stay nearby, she can go to Canada and work there for a year and then come back on an L1A, and then
Oh,
she'll be B1.
okay, okay, got it. So yeah, we'll check that options. Thank you a lot.
You're welcome.
Yeah, thank you for calling us. We have another caller, Rama from Texas. Hi, Rama. Hello.
Hello, can you hear me?
Yes.
Hello. Hey, hi, Prashanthi garu. I'm
Hello.
currently on L1. Hello, can you hear me?
Yes,
Yes,
I
yes.
can.
Go
Go
ahead
ahead.
with your question.
Okay. Yeah, I'm currently on L1, and my max out of my L1 is with all the gaps traveling to India. It's somewhere around September 2022. So my question is, I heard that if I go out of the country for 6 months or 1 year, and if I work from India for the same client or India or any other country, and if I heard that the L1 would be resetted and I can come back and stay for 5 years.
Yeah, so you have to be out of the country for 1 year.
Okay, so even before completion of this 5 years, if I go out of the country for 1 year and if I come back, so my L1 would be resetted and again I would be getting it for
Correct. You'll
5 years.
get a fresh period on your L1.
Okay. Okay, and also added to this question, I have a friend whose H4 is already pending for almost for 8 months, 9 months, and they never got biometrics. And on recent updates that there are no more biometrics, and so people will directly get the H4 approvals, right? So, ma'am, do you have any idea does this have any time period? How much time is it going to be forwarded, or because the processing time on the USA's website day by day it's going old. I mean, on not daily basis, but if you're checking weekly basis, it's going back and coming front, going back and coming front. So, is there anything we can do to get it prioritized? Because it's already been 7-8 months on the H4.
So I think you can request for an expedite because it has been 8 months and they're no longer requiring biometrics, so they should be processing these cases faster. With the biometrics, it was taking about 8 months. So without biometrics, it should be faster. So definitely a good case for opening a service request and also to request expedite.
Do you want me? Do you think the employer the principal who filed the H1, H4 both together, the employer can do the request, or my friend has to do the request?
Your friend is better off doing the request if it's a H4 because employer doesn't have to be involved in this. If you ask the employer to be involved, they'll do it once. They may do it, they may not do it. This way you have control over the process.
Okay.
We're not
And is
asking
there
about the
any
H1,
update?
so employer doesn't have to do it. We're asking about the
Okay.
H4 and the spouse, whoever that person is who have filed the H4 can do it.
Okay. And sorry, this added question to this, because they've mentioned last year before October, I guess they mentioned the premium processing will be open for the other categories, but we have not heard any updates on it. Is there any idea or anything information from your side where any of these premium processing will be open sooner?
Are you talking about visa numbers?
No, the premium processing, I mean, for the H4,
Premium
H4 EADs,
processing.
premium
Oh,
processing.
okay. Premium processing for what?
The EADs premium processing, these things were,
Oh, I
they have
doubt
given the
it. I
fees,
really
what is the
doubt it.
fees, all these.
I wish they do. I wish they will do it, but premium processing was never available for EADs. But yes, they did talk about last year as per
Yeah, they have given the fees
the house,
amounts
the bill
also.
passed. As per the bill that was passed, they recommended extended premium processing to other categories, but they have never done that. And if you look at the state of affairs right now, where they are not able to even process cases for 8 months, I don't know if they have the ability unless there is a complete revamp of the USCIS, the whole organization. I don't know if they will have the ability to do premium processing. That's why they haven't done it.
Yeah, but I heard that even the H1B regular processing, people are getting approval within 10 days, 15 days. Even the H1B
Yeah, that is
regular
with reference to
processing.
H1s. Yeah, that is H1s.
Yeah,
That is
but
not H4s. Yeah.
Yeah,
That
the
is
H1
H1s,
regular
yeah.
processing is also getting approved in 2-3 weeks of the regular processing, but the H4s
Correct.
have not been taking for almost maybe 8
So there's
months, 10
another
months.
reason for that also. I mean, it could be that they're intentionally not processing H4s because the previous, I mean, I don't understand why the present government is doing that, but the previous government wanted to stop H4 EADs, right? And wanted to stop a lot of things. So the way they could at least put a temporary stop on it was by extending the processing time, and that's what they
The
were doing.
problem,
It was and
because
putting hurdles and putting biometrics, etc., etc. They were doing that because that was kind of like a policy decision to give these
because the
H4s.
problem is,
Thank
sorry,
you.
because
Thank you. Thank you so much. And if you have more questions and would like to reach out to Prashanthi, you can email at prashanthi@readyesq.com or call 212-354-1010 or visit www.readyesq.com. So we have another caller, Srilata from Texas. Hi, Srilata.
Yeah, hi.
Yes, go ahead
Can I
with your
talk to
question.
Prashanthi?
Yes.
Yeah. Hi, Prashanthi.
Hello.
Yeah. I have a question related to my brother. My brother is currently in India. He actually got his H1B filed last year, which was approved just, for 2 years. And he also gone through the stamping and everything was well and good. But unfortunately, he have to move to the next job as the people, due to the COVID situation, he was not able to travel. And he took up the other opportunity with the other employer back in India. So now, as his visa is still valid for next 3 months, so will he be able to travel without being with the old company, or else like he have to go for a new, visa stamping again? The new company transfers his visa.
So he can, but the only thing is with the COVID-19 travel ban, he cannot come in. So I don't know whether that will be 3 months, 2 months, how long it will take, we don't know. But say the travel ban is lifted, then he can use an existing visa and come back on his, H1 approval. The H1B approval does not have to match with the visa. So he can use an existing visa and use that new approval and come in.
So he'll not be questioned anything additionally, right? Like when he's trying to enter the country about his previous employer documents, is there anything we have to take care?
No, you're going to show the new 797. You're not going to show the previous documents.
Oh, yeah. Got it. Like, and moreover, if in case, he's coming to the US and planning to go back to India in some time for any reason, so will he be directly eligible for the Dropbox?
If it's yes, because it'll be an extension then, so he'll be eligible for the Dropbox.
So no conditions like change of employers would be applicable, right?
No, it's still considered to be a revalidation of an existing visa. Doesn't matter that the employer changed.
Oh, I got
Okay.
it. Yeah. Thank you. Thank you so much.
You're welcome. Bye.
Thank you so much for calling us. And viewers, if you want, you can call us on the numbers on the screen for questions related to immigration. And today we are discussing on L1 and other alternatives for H1B visa. So, and if you have more questions also, you can directly reach out to Prashanthi. And you can email prashanthi@readysq.com or call 212-354-1010 or visit www.readysq.com. So, Prashanthi, coming back to your question, we are on L1 RFEs. So, like this RFEs, are they like the approval rate for this RFEs are like high or they get rejected, like H1 or?
Yeah, it's recently they've been cutting back on the L1 RFEs. I mean, they've been cutting back on approval rate for L1s. So we are seeing a lot of RFEs, and we're seeing some. Mostly they are approved, but there are some. We are seeing some denials as well. So previously it wasn't like that. I mean, there were hardly, we used to file and hardly any denials. But as you know, everything is becoming more difficult with USCIS, and this the L1s are no exception.
Mhm. So, in general, is it easy to get H1 approved or L1 approved?
I think it's easier to get a H1 approved because as long as there's a job, as long as the person has a bachelor's in that field, if all these parameters are set, the thing is the H1 is more predictable. Of course, with that whole right to control, and in the past, it was more difficult, but now it's becoming easier, more predictable. There are always exceptions to everything, but in general, I think if you meet certain parameters, there's not much scope for a subjective denial. It's more objective, more so than an L1, because especially an L1 multinational or it may be L1 specialty occupation, L1B or L1A, there's scope for a subjective interpretation of the duties. So when you allow the officer to decide, then depending on the officer you get, they have it within them. They have a wide box, a wide scope to deny cases. So that's the difference between the H1 and the L1. L1 is a lot of it is, especially with reference to duties, whether it's executive or not, it's a little bit more subjective, and based on which officers will sometimes deny, even though they shouldn't, even though they meet the requirements of an L1.
Okay. So usually what would be the time frame for L1, like from the starting till it gets approved? So what the time frame for L1, like how many days it might take or months it might take to get an L1 approved?
Well, usually, you can do premium processing, and if you do that, it usually takes 30 days to receive a response. That response could be an RFE. And once you get the RFE, then of course, it takes time to prepare and respond to the RFE because they're usually asking for a lot of information. And once you respond to that, it can again take a month or 2 months, even with premium processing, for them to send a decision. Meanwhile, if you're not doing premium processing, then it can easily take 4 to 5 months, 6 months to get a response on an L1.
Okay. So apart from this L1, do we have any other alternatives for this H1B visa?
So yeah, there are quite a few alternatives to the H1. The biggest one, that's why we talked about that at length, is the L1, right? But if the cap is over, then one thing you could do is wait for the second lottery, which will happen in the summer. That's in June, end of June, so July. They will do a second round of lottery based on if they find that there are a lot of people who have not filed, were picked but they didn't file. And so rather than waste the numbers, they should be doing another lottery, which they did last time. But we can't expect a big number from that, but maybe a few cases will come out. So you can keep your eyes out for that second lottery and hope that you get picked. In which case, then you will have to file. They'll give you again 3 months to file, so you have to file by November. And then, in addition to that, if your employer is cap exempt, which means that if they're an institution of higher education or if they're related or affiliated to an institution of higher education, if they're a non-profit research organization or a governmental research organization, there are certain companies that are cap exempt and you can file that anytime. So you don't have to wait for the next cap to become available. So for example, even if your direct employer is not cap exempt, but say you're an IT consultant, you're working for an end client that's cap exempt.
Okay.
Even then, yeah.
Yeah, we have a caller, Krishna from Chicago. Hi, Krishna.
Hi, Krishna. I'm Krishna. Good evening, madam.
Hello.
I have hello. Good evening, madam. My name is Krishna. I have one question because my wife and my boy on H4 actually they got a biometric information in the April 1st week, and both are given biometrics at near Chicago. But my wife record is updated in the status, but my kid record is not updated. Is it an issue, or do I need to contact?
So what is not updated? The fact that they gave the
Yeah,
biometrics is not updated?
in the H1 amendment status, we will check an online status case checking, right? About my wife biometric as of April 22, fingerprints released. That status is updated for my wife, but for my boy, it is not updated.
So they don't always update statuses on that website. They're sometimes
okay.
behind. So as long as you have done everything that you need to do, you're fine.
Okay. If it is not updated, also we can wait for the decision, but no need to communicate with them, right?
Correct. Yeah, that's fine. As long as you have gone and given the biometrics, your son has given it.
Okay.
That's fine.
Oh, okay. Thank you, ma'am. Thank you.
You're welcome.
Thank you.
Yeah. Thanks, Krishna, for calling us. And coming back to our topic, Prashanthi, you are explaining like other alternatives for H1B visa apart from L1.
Yeah, so as I said, the educational institutions, non-profit, research organizations, they all qualify for the exemption. In addition to that, the O category. So basically the O visas are reserved for individuals who have extraordinary ability in the sciences and in the arts or in education, business, sports. So those people can come in either on a H or they can come in on an O. So if you happen to be one of those people with some extraordinary ability, for example, maybe you're a famous chef, or at least not famous, but well-known chef, and you have a lot of newspaper articles written about you. Or you're a sports person, or you're coming in to work as an actor in some TV show or something. All those people come on an O1. So that is really the alternative to the H. It can be used as an alternative to the H. And the other good thing about the O is if you're an O, then you qualify for EB1, extraordinary ability. So you can get your green card faster because the EB1 is current, same as the L1. So again, not everyone qualifies, but there is a percentage of people that qualifies. And then if you, there's also country-specific visas, which can be used in lieu of the H1. There's the TN. So if you're a Canadian or a Mexican professional, the TN is similar to the H1, but it's not so complicated. You don't have to fill out all those cumbersome forms, especially if you're out of the country. You can just go to the consulate or go to the port, drive by road and go to the port of entry by road and show that you qualify for the TN. So to qualify, there are certain designated occupations for the TN. And that list also has, for example, it has a software engineer, systems analyst, and it says bachelor's in engineering is required. So as long as that's the position and that bachelor's in engineering the beneficiary has, they qualify for the TN. So for Canadian and Mexicans, that's a very good visa to have, and there's all these cumbersome requirements are not there. So that's a good visa to have. And then if you are from Singapore or Chile, you have the H1B1, which is the same as the H1B, but again has a separate quota, and the quota doesn't usually get over. So that's available throughout the year if you're a national of Singapore or Chile. If you're a national of Australia, a citizen of Australia, so it's actually advantageous maybe to take citizenship in one of these countries in order to get better treatment in the US, so then more windows, more doors open up. So the other one is E3. Again, similar to a H1, you have to show that it's a specialty occupation and that the person has a bachelor's degree in that particular occupation, and then they qualify. There's also the E1 and E2, treaty trader and treaty investor. That's for certain designated countries, not for Indian nationals again. So I heard that it's really easy to get citizenship in Turkey and some other countries. So people are actually doing that. They take citizenship, and there are agents that help to do that. So get your citizenship in a different country, stay there, and then come to the US, using this E1 or E2 and start your own business. So that's treaty trader and treaty investor. Then you also have the F1. If you're on an F1, then you can apply for CPT while you're studying, if your university allows you to do so, and you can work just as you would work on a H1. So, or after you finish your course of study, you have OPT, optional practical training. And if you have STEM OPT, it's, there's a 24-month STEM OPT. So altogether, you get 3 years on OPT and STEM OPT. So that's a good option, in lieu of the H1. You don't have to, even if you don't get into the H1 quota. I mean, I think you should apply immediately because you never know when you'll get in. But at least you have the backup of, continuing to be on an F1 on OPT or CPT. Now, for the EB1, like I was saying, if you qualify for EB1, either the O category or the L1 category, you can apply directly for EB1 from India and come directly on a green card. You don't have to come on an L1 or come on a O1 first and then come, to convert to a green card. And especially now with EB1 being current, you can just apply for a EB1 and come directly on that.
So you mean like there's no need of filing O1 visa or L1 visa?
Correct. Okay. You can directly file for an immigrant petition, I-140.
Okay.
And then once the I-140 gets approved, the consulate will call you for an interview. They'll take all the 485 documentation that you would take from here. You submit it at the consulate, and then they'll give you an immigrant visa. And then you come here and they process you for the green card.
Okay.
So that is also a really good option, especially while, EB1 is still available. So yeah, I think those are the alternatives, the major alternatives to the H1B.
Okay. So with all this like O1 or P1 or other country visas, even the family members can also come, right?
Yeah, so the O1, yes, so F1 people can't come on F2. For a lot of these, your TN, there's a dependent. For the E1, there's the E2. E3 also has dependent visa. So all these have dependent status, so the entire family can migrate and then eventually get the green card as well at the same time.
Okay. So I think, like you said, it's better to get another country visa first, then come here for getting advantage.
Yes, for people who are not able to come or don't want to wait, that is definitely something to think about. It's an option to think about.
So, can you provide more information on this E1, E2, treaty trader or investor?
Right. So, the E1, E2 treaty trader and treaty investor, there's a list of countries, and of course, India is not among them. But the E1 trader visa is suitable if the foreign national has a multinational employer who is willing to transfer them, like the L1. You're transferring from one company to the US to maybe start up a business here. Or there is significant trade between the foreign country and the US, and the employee must obviously have the skills to operate the business. And then, of course, you can come as a dependent. So that is the treaty trader. You're coming to do some trade. So, for example, you already have US clients. You are trading in, say, garments. You already have direct buyers. So instead of trading from India to the US, you open up a branch in the US and use that as your marketing base. And so then the garments will come to the US company, and then from there they will go to the clients. So that's basically trade. That's the trade that we're talking about.
And thank you so much, Prashanthi, for helping us understand the different options, alternatives for H1B visa. And viewers, if you have more questions and would like to reach out to Prashanthi, you can email at prashanthi@readysq.com or call 212-354-1010 or visit www.readysq.com. So next week we'll be back with more interesting topics. And this is Priya Koteti signing off. You are watching Sakshi Manasakshi. Thank you.